Thank you.
Almost. 1 second, please. We are recording.
Okay. Thank you, counsel. Good morning. We are here for oral argument in our case, SA 22-0189, Johnson versus Honorable Hartsell, State of Arizona. We are here for a virtual oral argument, and each side will have a maximum of 20 minutes for argument. You are not required to use all of that time. Appellant, you may reserve some, or petitioner in this case, you may reserve some portion of your time for rebuttal, although you are responsible for managing that time and reserving it. Because we are handling argument remotely, and thank you again for accommodating the court on this, I will be keeping time manually, and periodically I can alert you of your remaining time. Please feel free to ask if you want an update. If you reserve time, I'll do what I can to advise you when you're getting close to that. We are recording this argument and will ultimately post it to the court's YouTube channel. For clarity of the record, please identify yourself and your client before speaking. We, of course, hope that no connection failures will occur, but should one of the judges lose connection, that judge will review the recording later. If one of the attorneys loses connection, then we will suspend the oral argument until we can regain that connection. Please keep in mind that we have read the briefing, we have studied the record, and discussed this case in conference. And with that, you may proceed.
Thank you, Your Honor. May it please the court, Kevin Brady on behalf of Petitioner Amaru Johnson, and I do intend to reserve about 5 minutes for rebuttal. This court should reverse Commissioner Hartzell's ruling denying the motion to dismiss the petition to revoke probation, because in this matter, Commissioner Hartzell heard no evidence whatsoever, much less any new evidence regarding Petitioner Johnson's competency, and therefore Commissioner Hartzell lacked the ability to make any factual findings that would overcome the presumption of Mr. Johnson's continued incompetence. Ultimately, the question posed in this case is when the state refiles charges, or in this matter, a petition to revoke probation, that was previously dismissed due to incompetency, and they subsequently fail to present any evidence of post-dismissal events demonstrating or even suggesting a change in a defendant's competency prior to that refiling, must the court, the lower court, the trial court, dismiss the refiled charging document? And the answer is a clear yes. Now, when we look at the case laws that's in the briefs, Ryder v. Garcia, State v. Lewis, and even Oligschlager, an unpublished decision of this court, that gives a lot of guidance as to where the law is. The state's argument seems to be that the mere
Mr.
fact—
Brady, I have a question for you. You keep saying present evidence, but that, to me, when somebody says present evidence, that envisions a hearing. And we're talking now about a motion to dismiss. So what is it you would envision that the state would have to do to overcome the presumption? What do? They file, do they ask for an arrest warrant saying these are X, Y, and Z, and this is why we believe it? Or they file their petition to revoke the probation, listing A, B, C, whatever. I mean, are we talking about presentation of evidence or just allegations of fact that, if proved, would overcome the presumption?
And that's a good question, and that's one I think—
I try to ask good questions now and again. It doesn't always happen, but once in a while.
I think when we look at Oligschlager, for example, I think that provides us some guidance. I recognize it's unpublished. I recognize 2 of the 3 judges on this panel were involved in that decision, as was the prosecutor in this case. Essentially, Oligschlager identifies that Rule 11.6 of the Rules of Criminal Procedure allows a court to hold a hearing if there's a basis to do so with regards to competency. And in this case, with a petition to revoke probation, the petition to revoke probation could contain a statement alleging why the state believes that things have changed since the dismissal due to incompetency. That would be one mechanism. I do believe that in that case, there's information presented to the court. The court could then determine whether it's appropriate to conduct some sort of hearing, not necessarily a full-blown Rule 11 evidentiary hearing, because we're dealing with a presumption of incompetence. And what Heyman talks about in this presumption of incompetence is once there is any evidence that is presented, the presumption vanishes as though it no longer exists. But I do think it's incumbent on the state to present something. So whether that's a statement in a petition to revoke probation alleging what the state believes to be the change in a defendant or probationer's competency, were it a new charge or refiling of charges in a direct complaint or indictment, some sort of accompanying statement to justify the refiling, at which point the court could then do the necessary inquiry. That being said, in this case, there was no such presentation of evidence with the petition to revoke. There was no such presentation of evidence at any of the hearings before Commissioner Hartsell in the probation court on this petition to revoke probation. And procedurally, this petition to revoke probation was issued, and there was a warrant issued for Mr. Johnson's arrest that a court would then have to authorize. But there was no evidence presented at any point. And in the absence of that evidence being presented, I believe the court erred by not just dismissing the petition to revoke probation outright, because there was no information before the court to show that there had been some sort of change. And in essence, that puts Mr. Johnson in a position of being subject to repeated arrest, detention, and going through this process. And it's now been just over a year since he was first determined to be incompetent. And to date, the state has not presented any evidence in either of the refilings of the charging document in this case, and especially not the one at issue before this court, the May 31st petition to revoke probation. Now,
I have another question. Go ahead, Judge Campbell, I'm sorry.
If the petition had alleged a new violation of probation, would you be advocating a different posture?
I think what the issue in this case is, and that, again, another good question, but I think the issue in this case is it is a refiling. If there had been a completely new violation of probation based on new criminal charges, for example, I think we would potentially be in a different posture. The reality in this case, though, is Mr. Johnson was released from custody May 24th. On May 31st, a new petition was, a refiled petition, was
So
issued.
let's say on June 1st, he fails to report. They file another petition to revoke. Is that okie dokie in your scenario?
I don't believe it is, and that was in fact one of the allegations. The May 31st petition to revoke did have the term 1 violation that had been pending for well over a year in multiple filings of this petition to revoke. It did allege a failure to report and a failure to participate in the mental health treatment that were parts of the probation grant. That being said, Mr. Johnson was in no different situation alleging a violation of the same probation grant on essentially the same principal basis, and had not regained competency. And I believe that puts us into the exact same position we were in on May 19th, the day before Judge Lemire dismissed the petition to revoke for the first time. He was not competent, and the state failed.
Gray, isn't, and I will tell you, I'm wrestling with this. The failure to report and the failure to participate, are they new allegations every time they fail to do that, or are they a continuing violation?
The petition to revoke on May 31st, this time, those were new allegations. The petition to revoke that was previously dismissed and filed on February 1st did not have those allegations because Mr. Johnson went directly from Desert Vista from evaluation and was arrested at the hospital and booked back into custody and was never actually free or outside of a detention facility.
I'm looking at the February, and I'm just to make sure that we're on the same page. I'm looking at the February 2021, the Johnson's probation officer petitioned to revoke his probation due to new charges. And because he absconded, did not follow GPS program rules, and failed to participate and cooperate in mental health screening and treatment. That's what was filed in February. then that's when he was determined to be incompetent and unrestorable, correct?
All right, the February of 2021 petition to revoke probation is the original one that went with the original arrest on the what became the 2022 matter that was dismissed. After he was found to be not competent, not restorable on January 6th,
hold on.
there was a separate one
we make
February
it
1st.
really easy if you answer my questions. My question is, after that petition was filed, that's when he was found to be incompetent, not restorable. It was related to the February 2021 petition.
That's correct.
Okay, so then in January, he's into the restoration program, right? Now, when he was he petitioned to revoke in May of 2022, he being the probation department officer, I don't know if it was a he or she. The petition asserted Johnson committed assault and luring a minor for sexual exploitation, but that's the original. That's the original charge, correct?
Correct.
I mean, the new charge.
Right.
And then he did not actively participate and cooperate in mental health treatment and contacted a child without prior written approval. Now, is that a new charge or is that a continuation of what was originally dismissed back in, was it May?
In May, yes. The 21
in January.
Well, in January, and then
Whenever it was.
The 21D violation for contacting a child is related to the term 1, referencing the same incident. The failure to report was something that did occur subsequent to May 24th when he was released from custody, which was incorporated into the petition to revoke on May 31st. That being said, I think the court does identify something that's crucial in this case. I think the operative date really is January 6th of 2022 when he was found to be not competent, not restorable, and the charges were dismissed. Because at that point, we've been in this repetitive process without new information regarding competency of Mr. Johnson. And while there may be things that are happening related to his ongoing probation grant, essentially he is released from custody, and within 7 days, there's a petition to revoke that is refiled. It does add additional information to it, but still contains the same term 1 violation and 21D violation that were in the petition that was revoked back in January of 2022 on January 6th.
Even if the defendant is been deemed incompetent to stand trial and is on probation, the state still has a duty, the court still has a duty to supervise this individual because they are under probation supervision. How do we go about doing that?
How do we go about supervising this person? He can be supervised. One of the things that happened actually on June 1st, the day after the petition to revoke was filed, and that's in Appendix K, was that the court actually issued an order amending Mr. Johnson's court-ordered treatment to take him inpatient because of his instability. It was something in response to a petition by his team with Community Bridges. And when a person just simply is not functional, the court does have other mechanisms. He was on COT at the time, although not really benefiting from it at that point, to the point they believe that hospitalization was the best thing to put him in a situation where there's supervision. Granted, it's not the same as a probation supervision, although participation in treatment was one of those conditions. And that can assure
Mr. Brady, I'm a little confused. I'm a lot confused most of the time, but on June 1st, the Superior Court grants the administrator's request to order Johnson for inpatient treatment. But then he's arrested on June 12th. Was he ever taken into custody or for this inpatient treatment?
No. Essentially, at the time, there was the arrest warrant with the petition to revoke and this order to take him inpatient. And when he was located, he was arrested on the 12th of June.
So he was never he never did inpatient treatment from the June 1st order.
That is correct. So I think.
So could he, now, and I don't know the answer to this question, that's why I'm asking it. So theoretically, could he have been taken into custody based on the in custody order in and of itself?
I believe he could have been if he had been located by his team and turned into a hospital. Now, whether or not an arrest warrant would have been executed at that time, that's for law enforcement to decide, essentially, because it was there. But he could have been
Well, I
taken
don't
into
want to put
custody.
form over substance here because he was arrested on June 12th pursuant to the probation warrant. But is that a non sequitur if he could have been arrested based on his inpatient treatment order?
I believe he could have been arrested well, not arrested. I believe he could have been detained by his team and taken inpatient, but not arrested on the order.
That's a distinction without a difference to me. If you're taken into custody, that's an arrest.
I mean, ultimately, where he goes would have been a different setting, into a secure mental health facility, as opposed to into a jail pending a probation violation. Ultimately, though, there was no evidence presented before Commissioner Hartsell to show that Mr. Johnson had in fact regained competency, or even evidence suggesting that. The state in its pleadings cites to a lot of information that is pre-January 6th to somehow reason that he must have been competent and they could do this refiling with a petition to revoke probation. But that's really nothing more than an exploratory refiling to see if he was in fact competent. And that's something that due process doesn't allow. The plain language of Ryder says specifically that post-dismissal, so post-January 6th events, have to suggest that he's regained competency. And the evidence here, none of which was ever presented to Commissioner Hartsell. He was in the absence of information, making it impossible for him to make any reasoned factual findings, whatever they may be, deprived him of that opportunity. But the evidence...
I want to ask one on that very point. In reading Commissioner Hartzell's order, he says he denied the motion, and he just decided he cited Ryder. I'm not sure why he denied the motion. Does that make any sense?
It makes a lot of sense, which is why we're here right now, Your Honor. That I struggled with as well, because at the hearing, if we go back to the minute entry from the hearing in July, which is Appendix I, there was discussion as it's categorized in the minute entry. Discussion, nothing more, but there was no evidence presented. It was a conversation about it. There was argument back and forth on how people interpret different things, but there was no actual evidence. And as we know, the comments of counsel are not evidence. So in the absence of evidence suggesting that post-dismissal events would indicate Mr. Johnson was competent, what Commissioner Hartsell did was error. And for that reason, we believe that his ruling should be reversed. And I will reserve the rest of my time unless there's any questions.
I do have one more question. I don't know. So if Commissioner Hartsell had simply said, okay, I'm not going to roll in your motion to dismiss, but state you need to amend your petition to include what you believe is the basis upon which he's regained competency. Would you have an issue? I mean, isn't that what Commissioner Hartsell should have done? Is make the state set forth its basis?
I agree the state should be setting forth its basis to believe that something has changed, which they did not do in this case. I do believe they should be doing that up front, though, and not a month and a half after a petition is filed and Mr. Johnson's been held in custody for about a month.
But you just told me that he could have already been held in custody, well, with the in-treatment program. Right.
Because he was held in custody on the petition to revoke probation, the petition to revoke probation alleged no information suggesting he had regained competency. There was nothing for Commissioner Hartsell to go on, and it was error to deny the motion to dismiss. And I will reserve the rest of my time.
Thank you, Mr. Brady. Ms. Warzinski, sorry.
That's okay. Good morning. This is Julie Warzinski. I am arguing for the Maricopa County Attorney's Office. Just to address a few of the questions that the court has asked petitioner, Oleg Slogger considers violations of probations to be refiles, whether they're alleging new term violations or not. So I think that was the meaning of Oleg Slogger, was that probation violations, regardless if it's of a new issue or not, is considered to be a refile because the underlying case, at least that is my takeaway from Oleg Slager. The big confusion in this matter is the difference between the presumption of incompetency and the impediment to restoration to competency. In this case, I do feel the need to point out that the defendant, what we are talking about is an actual class 1 misdemeanor, that the defendant has been in custody for approximately 711 days. So if there was a revocation, his probation would need to be terminated because he's already served all his time. However, the state does also believe that this is a statewide importance issue. So I don't think that that moots the argument for today, but I just wanted to make the court aware of that because I only discovered it on Sunday when I was preparing, because I don't do the underlying case. I just do the competency part of it. But I just wanted to make sure
Ms.
that the court was
Warzinski,
aware.
first of all, it's good to see you again. And
Hello?
second of all, why should he still be in custody, period?
Well, because, Judge, and then I had to research this, because you only count the time that he is in custody for the violation, and that is well below the 180. Now, had defense counsel done a different motion, like to terminate probation, I don't know if we would be in this case, but we are. And I just wanted to make it aware. And regarding the time that he is available in restoration, there is approximately, I believe he has served 4 months. So there would be 2 months left, even if we needed to go into restoration. Defense counsel and Oleg Slager talk about a change in circumstances. And when we talk about the difference between a presumption of incompetency and impediment to restoration, what we're talking about is the reason for the incompetency to begin with. And in this case, it's because the defendant was refusing medication. So the state has 2 options. If a defendant is refusing medication, we can ask for a cell hearing where the court could order the defendant to be forcibly medicated for restoration purposes. We can also then ask for a civil commitment. We have attempted to ask for cell hearings. Currently, the theory of the court in the 2 judges that are hearing these matters is to explore the possibility of attempting a civil commitment because they believe it's less intrusive. So that is what we did in this matter. When the doctor came back and stated that the defendant was incompetent and not restorable because he was refusing to take medication, we did a dismissal and we sent him for civil commitment proceedings. When the state was advised he was placed on a civil commitment order, which means that the defendant in wherever he is could be forcibly medicated if he refused, we rearrested. When we did that, the underlying case, as you are aware, was dismissed. The probation department filed this probation violation by themselves. The county attorney's office had nothing to do with this probation violation being filed. And you can see that the defendant was not following what he was ordered to do. So that is why probation filed this new probation allegations. The procedure regarding whether or not the defendant, the mental health or pickup order, and it's really a pickup order, Judge. It's not really arrest him to put him in jail. It's arrest him to transport him to a facility, a medical facility. So he would have been transferred to yes.
Is that's still an arrest warrant? Right?
It is still an arrest warrant.
Yeah,
I would agree
okay.
with that. And in this case, what would have happened is he would have been transported to the hospital where they would have stabilized him and released him back into the community. This is not something where the defendant would go and have months worth of treatment. It's a stabilization process. So
and that's the way I read, the administrator's request, is that they needed some stabilization. The problem I had is he wasn't picked up on that type of, because he wasn't there. Well, first of all, I didn't know if he had been picked up and released, but he was arrested on June 12th because they believed he was involved in a trespass and
There was a
he
warrant.
had this probation warrant, correct?
Right. So
Um,
when they arrested him, they could have taken him to the hospital, or they could have taken him to jail. And the police officers decided to take him to jail. If they had taken him to the hospital, he would have remained there until he was stabilized, and then they would have brought him to jail. But the same thing that happened would have happened when he went to the hospital happened in the jail, because he's under a court order for treatment now. He can be medicated, and if he refuses, he can be force medicated because there is a court order for treatment in place. That is the difference in this case, and that is the difference that did not occur in Oligslager. When she was taken to the hospital, she was released and there was no court order instated. So in that matter, there just wasn't a change in circumstances. In this case, we have a change in circumstances, and that would be the civil commitment hearing. The state would argue that even if the civil commitment hearing had not been granted, we would still be in a position where we could rearrest and ask for a cell hearing if necessary.
but that's different. But you can do that without having a probation violation or a new charge.
Well, we would have to have a new charge, Judge, because we can't ask for a hearing for restoration unless there's a new charge pending, because there's no jurisdiction. If you look at Ryder was a motion to dismiss based on lack of subject matter jurisdiction. It evolved into the hearing that it was because of the procedurals that took place. But the ruling was, what Judge Swan stated was, we hold that subject to due process limitations, the state can refile the dismissed charges and renew its efforts to restore the defendant to competency. It says renew efforts. So if the defendant was already, if the state had to prove that the defendant was already competent, what is the language about renewing? There's confusion within that very case, because it was not, again, focused on whether or not the state could refile charges after incompetent, not restorable. Their argument was because the defendant was under a court order for treatment, the prosecution lacked subject matter jurisdiction.
Can you walk me through a hypothetical, just
Sure.
so I make sure I'm following what you're saying? Defendant is put on probation. Defendant commits new charges, is found not competent, not restorable, is still on probation. How does the probation department exercise their authority over that defendant if he's not competent, not restorable? What's the mechanism? How does it work? Dollars to donuts.
Well, Judge, and that's a difficult question, because often what will happen is a defense counsel will file a motion to terminate probation based on the continued incompetency. In other cases, like this one, where it's a medication issue, competency is fluid. So if the defendant, even let's say they didn't file a probation violation in this matter, what we have from historical records is that when the defendant takes medication, he stabilizes and becomes competent. And that is in the historical record in this matter. So even if he wasn't picked up on new charges, if just by the process of being on medications, he could be competent in the community. It just wouldn't be being assessed in terms of a court revocation proceeding. So that is the issue. And I'm sorry, I'm a little sick, so my voice is weird. That is the situation we're facing when a defendant chooses, and they have a constitutional right not to take medication, but when a defendant chooses not to take medication, and maybe that's for the reason of being found incompetent, there are mechanisms in place that the state has, going cell hearing, going civil commitment, that can force medicate a defendant. And that is what happened in this case. When you
But
look
it
at,
happens simultaneously with a new petition to revoke or a refiled petition to revoke. And so when we got this refiled petition to revoke, you're talking about criminal charges that can result in a prison sentence. It's
yes,
not simply mandatory medication or court-ordered treatment. So what I'm wondering is, in this petition to revoke his probation, there's no allegation that he's regained competency or that it's necessary for him to have treatment to regain competency. It sounds to me like you're saying that should happen through a cell hearing or court-ordered treatment, not a petition to revoke. But that's
well,
not the question before us. What's before us is, can you continue to file a petition to revoke probation and keep arresting this fella over and over again with no showing that he's regained competency and can stand to face those criminal charges that may, or the revocation of his probation, which may result in prison? So on one hand, you're talking prison, and then we're talking restoration to competency and mental health and treatment. But one of these things is not like the other one. What has to be alleged in the petition to revoke is what I'm wondering. And was the petition to revoke here filed in error? Should it have been a request for court-ordered treatment or a cell hearing?
well, Judge,
That's what I'm not making the connect.
in this case, and you have to realize that a probation violation is not filed by the state. It is filed by the
I'm
probation
fully
department.
aware.
So we do not have control over whether or not they file a probation violation. But in this matter, what currently happens is if there is, if the probation violation is filed, let's say a defendant is found incompetent, not restorable, and then 3 months later he commits a violation of his probation. If the state has information that the circumstance, once we find out about it, we can research it and determine if there was a change in circumstances and go forward. If there
And
wasn't a
amend the
change,
petition to alert the court that there's been a change in the competency of the defendant. What I'm having a problem with is, I get it. The state doesn't file a revocation, but the state prosecutes a revocation of probation. So at some point, the state, a lawyer, needs to look at this and say, we don't have a prima facie showing that this guy has been restored to competency, and we probably shouldn't move forward with the revocation. We should change this to a different procedure. Wouldn't that be what's on the state in this circumstance?
well, not to change it to a different procedure. What we would do is dismiss it and dismiss the petition to revoke probation.
Which is to change to a different procedure.
Well, except
precisely my point.
Right, except, Judge, we wouldn't civilly commit him on that basis because the state would not have the power to civilly commit him. We only have the power to civilly commit him when the court orders us following the original order. So once
So
there was
there fundamentally is a gap between restoration proceedings, court-ordered treatment proceedings that probably needs to be addressed in the future by the legislature. You would agree with that?
I think what occurs is if the defendant is found incompetent, not restorable by the court will issue an order, yes or no, on medication. If the defendant is already taking medication and it hasn't made a difference, if he's voluntarily taking medication, there is no need for a court order because he's voluntarily taking medication. In those cases, the state would not just refile the matter after he was released because he's already taking medications. We would need to show something else. In this specific case, the defendant was found incompetent, not restorable. The defendant was sent to the hospital. The defendant was placed under a court order, and the state was advised that, and the state was advised he was being released to the community. That is what triggers the arrest. In the two other cases, defense counsel.
Ms. Rosinski,
yes,
at that point in time, you don't know whether or not he's competent. You just know he's been released.
We know that he is being released and that he was, yes or no, placed under a court order for treatment. So in this case, what the doctor had said is that he needs to be placed under a court order for treatment in order for restoration to take place. In this case, now we know that he's under a court order for treatment, and the impediment that the doctor indicated was the reason he couldn't be restored to competency has been removed. When you look at the other cases that defense counsel cites, Lewis and Noel, first of all, those talk about post-restoration while pending an 11.6 hearing. In this case, he's already had that. That was when he was found incompetent, not restorable, and the case was dismissed. So those really don't have anything to do with Ryder. And again, what Ryder says, you can't continuously rearrest somebody to keep him in custody. That wasn't done in this matter. And it can be barred by the statute of limitations, which has not occurred in this matter at this point.
But following up, and I'm on Judge Campbell's question, it seems to me that once the state in this case became aware of the probation revocation, the more prudent course of action would have been to dismiss it and ask for it to what you'll call a cell hearing, or ask that he be placed back in the with the restoration, the inpatient person.
Well, Judge, we would not have any indication that he had a mental health pickup order, because that's a mental health order. We're not entitled to know those because that's HIPAA protected.
But the probation department
back
does.
into restoration because we don't know, and we wouldn't have addressed the cell hearing because he's already under a court order. We don't need a cell hearing at that point because the impediment has already been removed.
So here's
But
my
the probation department would have known what was going on because they have access to this information pursuant to the standard probation department rules require the defendant to either authorize or allow for them to monitor his treatment.
And Judge, that could very well be, and the probation department could have decided that he could get the same treatment while he was in jail, which was the medication. He wasn't compliant with medication when he was released, but he will have to be compliant with medication when he is in jail. And they could have also maybe thought, I mean, and I can't speak for the probation department, but there's a lot of different things that could happen. If he was still not stable after the jail term, after they dealt with the probation violation, they could have sent him for mental health treatment. Anybody can petition a defendant. You just have to have witnesses. The state just has to wait until the court orders it. So in this case, Ryder does not bar the refiling of these charges because the statute of limitations is not up, and we have not continuously refiled to keep him in custody. There was a current violation that the defendant was pending that was a new violation. And while it might be considered in the same case, it is a new violation.
And you're saying that because you're saying every time he absconded or didn't participate, that's a continuing a new violation.
Yes, it's a new violation on an old case. So we do have to show a change of circumstances, which we have with the COT, which removes the impediment to restoration. So if you say we can't rearrest after a civil commitment, all a defendant would have to do is kill someone, stop taking his medication in jail, and then the state's precluded because we're never going to, there is no process of restoration after the case is dismissed. There is mental health treatment, but there is no restoration. So the state would never be able to prove a change other than the change to the impediment of restoration, which is what they have shown in this case. So the state believes that based on the totality of all of the information in this matter, a refile was appropriate and going forward is appropriate. And again, in this case, of course, because he's already been in custody, if and when he revokes probation, this case will be done. But because it is of statewide importance, for other cases where the time frame would not be the same, we believe that an opinion is important. Thank you.
Judge Ferdia, you're muted.
Thank you, Ms. Warzinski. Thank you. Let me reset my timer here. Mr. Brady, I have you at roughly 3 minutes.
Thank you. To go to what the state was just saying about an impediment to restoration, the standard isn't that an impediment was removed to restoration. if we look at the minute entry from January 6th, there was a stipulation on the last page that was included in that minute entry that said, upon stipulation of the parties, both agree that court-ordered treatment or medication may affect future attempts at restoration. Not that it will, but that it may. So this idea that the mere existence of a COT for a petitioner is sufficient to change the situation in terms of his competency, that's really a non-starter, because I think we all know that there are people who are medicated who will never become competent. There are people who do not take medication who are competent. There's a lot of possibilities when it comes down to this. And the state's just assuming, one, that he was receiving treatment in jail, and two, that treatment was having an effect. But none of that evidence was
Mr.
actually
Brady,
shown.
I'm sorry to take up your time because I know you don't have much of it, but this case is a little unique because based on what you told me earlier and what Ms. Wierzinski just told us is when the provider said, hey, he needs to be stabilized and got an inpatient order, he was never picked up. So we don't know whether or not medication would have affected his competency, do we?
That's precisely the problem. We don't know that, and Commissioner Hartsell never actually considered that because it was never set forth to him that there was anything that had changed in terms of his competency. Ryder requires that there be evidence post-dismissal that suggests that there's been a change in competency. And the fact that there's a COT does not suggest that.
If the probation department had put in all of this information in and said, on June 1st, the provider said he needs to be stabilized. He's never been picked up. So we need you to pick him up so that we can forcibly medicate him. That would have been sufficient to meet the Ryder standard.
I don't know that it would have met the standard because it doesn't necessarily address competency. It would have been information, but the fact that he was unstable at the time, I think, may have actually shown the other way, that he hadn't regained competency. Of course, that gets into what information a commissioner could have considered on the filing of a petition to revoke to allow us to go forward. But that information simply wasn't provided to the court, which is why we are where we are. And to go back to your earlier question as to why Commissioner Hartsell didn't grant the motion to dismiss, that's why we're here. But essentially what the state was arguing is that they need to be able to refile or proceed on prosecution of a petition to revoke or charges to find out if they can do that because they have no other mechanism. And while the legislature may need to resolve the procedure at some point in the future or the court through a rule change to deal precisely with this issue, the issue before the court right now is whether or not Commissioner Hartsell erred by allowing this petition to revoke to go forward in the complete absence of information provided to him that Mr. Johnson had regained competency, or even that there was the suggestion that he had regained competency. This idea of change in circumstances is not the law. Yes.
Last moment. Last thoughts.
Okay. The fact that he had that there may be a change in circumstance because of the mere existence of a COT is not just positive. It does not prove anything. As the language in that January 6th minute entry shows, it may or may not affect things, and it's really a non-issue. Thank you.
Thank you, counsel, for your arguments. We will take this matter under advisement and issue our decision in due course. And court is now adjourned. You may hang up now. Thank you.